Have you wondered what financial advisors actually think about finances? This is your sneak peek at the conversations within Financial Design Studio. Michelle Smollenberger, the CEO here, will be your host as you go behind the designs.
All right, welcome back to the podcast. I'm your host, Michelle Smollenberger, a financial advisor and partner here at Financial Design Studio. And this podcast, Behind the Designs, is all about giving people an inside peek at how professionals think about their industry. So we're starting a mini series where we're interviewing outside professionals. So far, we have really talked a lot with the partners here at the firm. And so we've just kind of found that there's some issues we want to get outside professionals' opinions on. So you can stay tuned for more of these. But today we have a special guest, Heather Walser. Welcome, Heather.
Thank you so much for having me. I'm happy to be here.
Yeah, you're welcome. Heather is a shareholder and partner in charge of the estate planning practice group at Lavelle Law. And I've known Heather for several years. We've talked about estate planning and financial planning for a while now. So Heather, why don't you tell us a little bit about yourself, just kind of how, maybe how long you've been in estate planning and...
Sure. So like you said, I'm the partner in charge of our estate planning group at the firm. I've been with Lavelle since 2009, but I'm going to choose not to date myself and tell you how long I've been practicing law. But my focus is entirely all aspects of estate planning, both the planning side and also, to a lesser extent, the implementation and management of the estate after someone's death. So that is my focus all day, every day. It's what I really am passionate about. I love working with clients, and what I especially enjoy is helping to understand their wishes specifically and implement them and counsel them on the best way to do that.
Yeah. And I'm sure, I think this is one of these subjects where we both know it's really important that you have this in place, but it's also something that's really hard to talk about because people are making decisions for what they want to happen, which can seem really final, but also relationship-wise and can create a lot of issues of who's the favorite, just things like this can stem from this. So I'm sure that's a really tricky balance.
It is. And, in doing what we do in my group, for us, it's kind of a no-brainer. We talk about this all day, every day. And so to us, the worst scenario is failing to do any planning at all. Yeah. As much as it can be uncomfortable and difficult to navigate and talk through and make these decisions, it is so much worse when we see the back end when nothing has been done and everything is on fire, so to speak. Yeah. So we recognize absolutely it's not pleasant, and it's not usually anyone's first choice of things to discuss or spend money on either, but it is so important.
Yeah. I think too, one of the things, once you go through the process, it's like a weight lifted off your shoulders because if something happens, you've written down what you want to have happen, who you want to be in charge. So now people have something to follow. So it's also, while it can be hard, it's also something that's a huge relief.
Absolutely.
Once you have them in place.
Oh my gosh. And such a gift to your loved ones, truly, because if you just lay things out, it makes the process so much easier and better. And the hope is that you'll put them in place and you don't need them for decades.
Exactly. Yes. No, that's great. All right. Well, thank you. We're happy to have you here. So this is going to be fun because during COVID, like right at the beginning, we were trying to figure out how do we inform clients of things that are changing. So we kind of did like a mini series back then. And I think it was like on our back deck.
It was.
So it was kind of like, hey, Heather, do you mind standing 10 feet apart? And then we can just ask each other questions. And what was so interesting, though, was during COVID, there was a lot of things that changed. So, we just even think of basic things now, like you get you decide who's going to be in these places in your documents, then you need to get them signed and notarized. But during COVID, even getting a notary was tricky because of proximity to each other, things like this. So this is hopefully kind of a catch up of since then, what things have become permanent. So like those things, did they stay in place or have they reverted back? And then also kind of now what are we seeing in estate planning? So that's really the purpose of today. But let's just start there. Yeah. Any of those things that were in place, have those those stayed?
Yeah, so you're right. I mean, it's almost cliched to say it was a crazy time, but it really was. So in estate planning, we're very, it's kind of the old ways are what we need to do to implement the documents. We have to have a wet ink signature or multiple wet ink signatures. We have to have in-person witnesses, a notary public, and certainly during COVID, that was highly challenging because just to get people in a room together was not possible. So during that time, there was an emergency order that allowed, under Illinois law, for us to do video signings. It was a great option at the time, and I was really proud of my team at the firm because we just pivoted and started doing it. The emergency order was signed, and we did our first video signing, I think, 2 days later. Now, unfortunately, I guess you could say those signing protocols have not been extended. So we are back now to in-person signing. That said, though, one sort of positive from that experience is that we have really begun, or continued, I should say, to use video to interact with clients. So those initial meetings to talk about things it really took hold, and it's been a huge improvement, honestly. It helps with scheduling. People can have these difficult conversations with me from the comfort of their home, which is really wonderful.
Yeah, I feel like that's one of these things that we've talked about is, okay, so great, now I finally built up the courage to kind of get these documents in place, and now being able to be at home is great because you're in the comfort of your home, and it might be easier to kind of choose, or, I don't know, sometimes when you just go out of your house, like you're in a different environment, it just changes our thinking, so we're kind of oriented to home and might help. No, that's great. That's interesting.
Right.
I guess just that piece right there that was put in place, those were kind of emergency options, is really the purpose of having like in person, all of these things is it because estate planning documents are so final, like the courts, judges, they just want to make sure that everything, is legitimate. There's nothing, people are signing things remotely and we aren't sure if people who are who they say they are or witnesses really were there. Is that kind of the thought process behind that? Or
that's a big piece of it. Primarily what we're trying to do is fend off potential arguments. Once someone is deceased, they're not around to explain what their wishes were, which is why we want to put people through those paces of it's all on paper, it's, it's been drafted, it's been reviewed multiple times, and we really want to lock everything down in a way that makes it clear to everyone and there's no confusion. That said, we, as much as we want people to make decisions that are forward-looking, what's interesting and sometimes complicated or strange about doing these documents is you have to do them, the way we counsel clients is you have to do them for this snapshot in time of, okay, we hope, and statistically we can usually be confident that maybe you're not going to use these documents for hopefully many decades. You're going to live a long time. And at the same time, we have to plan for today's snapshot. If, the bus runs you over tomorrow, what's the plan? So we do want everything to be official and formal and notarized and signed. However, we do have the ability to tweak and adjust over time. And that's something I think clients get worried about, that idea, and they put it off because they feel like they're not ready to make these big final decisions. But we try to remind people that, look, just think about the snapshot right now. Think about right now and what would need to happen. And if a year or 2 or 3 from now we need to tweak it, absolutely, that's what we'll do.
Yeah, no, that's a great point because that does give, again, it gives some relief of, okay, I've gotten these documents in place. That's a relief. But if anything ever changes, we just update those so that they're reflective of that too. I think that's a really good point. Yeah, no, that's really helpful. As advisors, we've noticed kind of this growing number, just kind of talking about like all the people involved in these conversations or these thoughts. One of the things I think that people really are trying to accomplish is when something happens to me, whatever assets I have, whatever needs to be taken care of is going to be taken care of. But also the people that I want to have any money or assets remaining, I want them to have it in these percentages or in this way. And so really, I think when we think about that, like the ultimate goal of having these in place is so that the people we want to have these things or money, if we're just accomplishing that, then by putting these in place, it reaches that goal. And so as the beneficiary, you can then think, oh, this was my parents' goal. So so it's kind of like one of those things where it may be hard to kind of get started, but once you do, I think every side can really realize, well, this is doing a lot of things, but ultimately like accomplishing that big goal that people want to pass things on.
That's right. And you touched on a really good point in the sense that sometimes there are difficult decisions that have to be made, you know, different percentages for different people, different access to the money, that type of thing. But it really truly is, if you lay it out, it can be beneficial for everyone. Just a super quick little, war story here. We had a client, very difficult family dynamics, and several children, many children who did not get along. And there was a lot of difficulty in the family. The matriarch, the mother, was very, very clear in her estate planning documents. There were not going to be equal divisions among the children, which often that's just an immediate introduction for fighting. Her documents were very clear. She updated them regularly. And the son, who was the trustee, actually told us after she passed away, you're going to think I'm making this up, but it's 100% true. He told us, my siblings and I have never gotten along as well as we do now because everything was so clear. Yeah. And he was the trustee, and he was able to tell his more difficult siblings, look, mom was super clear in her wishes over 3 different iterations of this document. Yeah. So, there's only upside to it.
It's so interesting. Yeah, I've seen clients who have kept things updated. Not every child is the same.
Right.
Everybody's different. They act different, and that's okay. Everybody's unique. And I can think of clients who have updated documents, and maybe like during their lives, they were helping their kids, whether that was a house down payment or a business investment or something. And then when it came to kind of that final distribution, they got, a lesser percentage because they got more during their life. But I just think, and those conversations like those people were having with their kids. Yeah. And so I just think the more you're communicating during that process of, okay, I'm happy to help you now, but this is going to come from, your later amount. Right. But I feel like in those situations, they've gone really well. Yep. Whereas maybe if you put in your documents, all right, this person gets 10%, and then, 80, and you never tell anyone.
Never explain
that's
it.
a big shock.
Yes.
So I can understand. Yeah.
Right. Exactly.
Kind of that trouble later.
Exactly.
Okay. Well, so kind of talking on that same kind of line of thinking, I think even we've noticed like more kids or adults managing their adult parents' finances. Even in this, I think that's even one decision that can be tricky of who gets to manage things, who gets to distribute. This person isn't making the decision of who gets how much. They're literally following the rule of this is your percent of this amount.
Yes.
But even that decision of who is helping, who lives close, things like this, talk us through a little bit of that. Sure. Is that even a hard decision for people to make and think through?
So it is sometimes. Sometimes the choice is very obvious. You have a child in the family who's an estate planning lawyer. That one was really easy for my folks. But we often have to counsel people away from, there's this mentality of almost that it's an honor or that my firstborn child is going to be hurt if I don't pick them. But we really try to counsel people toward making those decisions solely based on who is the best person for the job. Because it's a job, it's work, and it requires organization, responsibility, being good with money. So we talk around that a lot. And there are certainly instances, a lot of times the child who lives the closest is the default helper. Yeah. And that's okay. But we just always try to at least say, let's talk about maybe if the child who's physically close can be helpful in those kind of ways, but maybe if they're not the best with money, let's problem solve that, or let's strategize how to deal with that.
Yeah. Do you ever see it work well when there's multiple people? So I guess in these positions, we're talking like powers of attorney, trustees, executors. Do you ever see it work well where there's multiple, or is it almost always easier when it's just one person?
We find, as a general rule, co-trustees, co-executors to be more difficult than anything else. It just, if for no other reason, that even if the people you've named are civil and get along well, even just things like, well, now they both have to sign the real estate contract. Now they both have to handle the closing, just those kinds of just administrative type hurdles can be enough to say, look, it's not, again, reinforcing, it's not an honor, it's a job, it's work.
Yeah.
And you can make it as the person planning, you can do so much to make it easy on them. The more you set things up in advance, because your point is such a good one that I think sometimes gets lost, or people, it's just not clear. Yeah. Being the trustee or executor doesn't mean you're the one who gets the money. It just means you have to follow the rules that the parent or loved one, or the deceased person laid out. It's a really good point you're making. There's confusion around that sometimes.
Yeah. I can think of clients who don't have kids. They don't really have family. There's no relatives. Maybe everything's going to charity or things like this. Are there people or places that you recommend for clients, or is this really kind of where Lavelle can step in and you guys do this for clients? So maybe speak to someone who is like, who do I even name in this? Maybe I don't trust any of my kids and actually want a professional to do this.
That there absolutely are professionals there, and that's part of when we're working with clients. Our probably biggest focus is we want to understand the dynamics and understand what the client wants. And really, to us, I often tell our clients what you get at the end of the process when you do your estate plan with us is documents, certainly, but the real value is our guidance and advice. And so when we have those conversations, and either maybe there aren't kids, or maybe the kids are not adept, or they wouldn't be able to handle it, or they're far away and busy. I hear that a lot. My kids are super busy with their lives and I don't really want to burden them with this. Absolutely, there are corporate fiduciaries who will do this. And even where we sometimes run into a problem when people don't have family members that they can rely on for this, corporate trustees are absolutely available. Where it can be a little more tricky is if you need help with healthcare decision making, or just kind of interim financial decision making under a power of attorney. So those are the pieces that it's really important that we talk about it and come up with solutions.
Okay. That's it. So you mentioned the power of attorney. This is a conversation we've had usually when we're explaining to clients, these are the documents you need to have in place.
Right.
There's some for when you're still alive, but you can't make decisions. Maybe you're unconscious, something like that. Yep. You need someone to make a decision for you. So that's your power of attorney. But then when you've now passed away, so you've got a trust, will, these documents come into place. Yep. So talk us through the different difficulties with being a power of attorney and needing to act, or being a trustee or executor and needing to act. Is there any difference between these, or anything that you notice?
Yes. So your explanation was spot on. So there are multiple different roles involved in naming people to step in your estate planning. Generally, from most of our clients, the sort of big overarching document, or sort of the funnel we want everything going through, is the trust, the living trust, or the revocable trust, sometimes you hear it called. For that document, you have to name a successor trustee. Now, that successor trustee will step in at your death, but also if you become incapacitated. And that's the piece sometimes people don't think about in doing these documents. It's like, what's going to happen when I die? Of course, that's important. Equally important, though, is if you become incapacitated. So the successor trustee can step in incapacity and manage any assets that are in the trust. Now, similar to that, there is a power of attorney agent under the financial power of attorney. In Illinois, we call it the power of attorney for property. That is a slightly different role in that often it's more of an emergency type of a situation, but that person only has access and governance over non-trust assets. So bank accounts without, that have just your individual name, that type of a thing. We find that for many, many reasons, during incapacity, it's much better for the trustee to be acting on as much as possible. So for as many of the assets to be in the trust and the person managing the finances to do it as trustee and not as power of attorney. Certainly power of attorney is important. You need that.
Yeah.
But in terms of, we're lawyers, so we view it from the possibility of fighting down the road, and trust, managing in the trust is far preferable.
Yeah. So let's talk a little bit more about that. So, I have a trust. I've put money, I've titled my account in the name of the trust. Yep. So now, mom or dad they aren't really making good decisions. Doctor, writes a note, or, it's basically we all agree someone should be managing things. So if I needed to, they're still alive, but I need to make decisions, or I need to act financially for them. So I could use that power of attorney for property to do that. Or I could, if I'm listed, so as the trustee, they no longer now act as trustee because it moves to the next person in line. So let's say that's you. So now, instead of whatever that is, you would basically, want to say, oh, I'm the trustee, instead of trying to say, well, I'm the power of attorney.
Yes.
And why do you feel like that's easier?
So on the first line is, it's typically easier to deal with the financial institutions as a trustee than as a POA. In part because certain custodians and certain banks, financial institutions, they have their own separate power of attorney document.
Yes.
And so you can run into some roadblocks in the sense that if you have a parent who has lost capacity and cannot sign any longer, but the account is in their individual name, if they haven't done that POA, even if you have the legal, I've had many arguments with custodians about this. Even if you have a valid legal Illinois POA, they will not recognize it just contractually as part of the terms of their investment. And a lot of people don't realize that. Contrast that with if the account at that same custodian or financial institution is titled in the name of the trust. In that case, the successor trustee generally just provides documentation that says the parent is incapacitated, and they seamlessly step right in and manage everything. So that, from that standpoint, it really tends to be a lot more seamless. Now, there are going to be some things that are just unavoidably subject to the POA. So, dad's in the hospital and someone needs to call Comcast and cancel the NFL Sunday ticket package or whatever, that has to be the POA.
Or move that subscription to the hospital TV so you can get it there if they don't have it there.
Exactly. So, you need both. You absolutely, the power of attorney for property is vital. Everyone needs it. But just in terms of the management of the big financial assets, doing it as trustee is the better path. So that's first point. It's better on the front end. Second point is, if you are the child who's managing this and who's helping and doing everything above board, you have more protection from a potential disgruntled sibling or family member who thinks that you're doing something wrong. You have more protection as trustee than as financial power of attorney. And that makes sense in the sense that certainly when you're acting as power of attorney, that is a huge responsibility. They both are, of course, but you have got to strictly manage every single penny for the benefit of the principal. And if you have a disgruntled sibling or someone, we see that sometimes. The sibling who's nearby is taking care of mom and dad, intimately involved with the finances and another sibling maybe doesn't live nearby, and not out of malice, but they just aren't involved in the day-to-day, they don't really understand the costs and the work and everything associated with that. So it can lead to some problems on the back end when the parent passes away and the child who's far away says, where's all the money? So that's some of our thinking as lawyers, is protecting the client who's doing a good job from being stuck with having to respond to a disgruntled sibling or something along those lines.
Okay. As a power of attorney or a trustee, so in those duties, are you required to give siblings an accounting? I mean, I think it's always nice when they do, but is it actually a requirement in either of those roles?
Right. So interestingly, that's part of the distinction between the two. Is the Illinois law governing the power of attorney's actions gives a much broader scope of people the ability to demand information from the agent. So heirs, siblings, more people can say, I want an accounting of everything you ever did as POA. And that's fine. If you've done everything above board, certainly you have nothing to worry about. However, it's still a massive undertaking to go back years and say, this is every check I ever signed. This is so. Contrast that with the trustee of the trust. The trustee of the trust is obligated only to account to the trust beneficiaries. Okay. So if you have an estranged sibling, and I'm sort of talking about the edge case, worst case scenarios, but that's when we get called, frankly.
Right.
If you have a disgruntled sibling who's been disinherited, as the trustee, you can kind of say, I don't owe you anything, which is a big protection for the trustee.
Yeah. No, that's huge. I agree on all of that. I can see like the side of, so as a financial advisor, seeing the accounts that you have to open. You're exactly right, where you have this power of attorney set up, but then, okay, I want to get added as the power of attorney, use this document to be listed on the Schwab account. Right. And you're exactly right. They have their own form. Yes. So now mom or dad has to be able to sign that form. But usually when you're trying to use a power of attorney, they can't. So it is really one of those things where this is kind of another thing where you want to get things put in place. And again, this is why it's really important that you're picking people you choose, because you don't want someone saying, well, I'm the power of attorney well before they need to act. I guess on that point, is there, like, what is normally required, or what do you guys normally need for someone to be able to say this person can no longer act like as power of attorney or trustee?
Yeah, it's tricky. I mean, most of the time it's a letter from a doctor that's required. And as much as that can be a bit of a hassle, it's important because we don't want there to be any doubt. We want it to be clear. And normally in those situations where someone is in memory care or early dementia, normally they have a neuropsychologist or a doctor who is intimately aware of their condition and can write those letters. But we usually want that hurdle just to keep everything above board.
Yeah. So it's usually like just a doctor's note. Do you find that's hard? So let's, like, maybe scenarios where they're not extreme, like it's not memory care where you actually have someone, but it's kind of more, I'm just even thinking like mom and dad really shouldn't be driving.
Yes.
It's those where
those are
it's hard. Their pride, I want to be able to do these things, and you don't want to take that away from them. No. Those are tricky. Do you find that it's hard to get people to agree in some of those situations, or do you feel like generally people kind of say, no, I think it's time? They could always still act even though you're added as power of attorney, but it's just making that available so it's easier when it's needed.
So what's kind of cool is that you can tell I'm very nerdy if I'm telling you this is cool. But in 2015, the power of attorney statute changed a bit. And one of the changes was actually to the healthcare portion, the portion of the statute governing the healthcare power of attorney. And it added an additional option for interacting with medical providers. So we used to have kind of a very binary choice of, my doctor can talk to you about my care when I'm incapacitated, or, and until then I'll make my medical decisions, or, I want my agent to make my decisions now. Those were kind of our options. Well, now we have a much more middle ground choice that says, on the healthcare power of attorney, I, as the principal, am going to continue to make my own decisions clearly as long as I can, which most doctors are going to default to that anyway. And at the same time, my agent can participate in my medical decision making. And so what that means is it was basically, we find it really useful in exactly that situation, meaning call the doctor and say, hey, mom seems like she's really slowing down. What do I need to do? Can she still pay bills? Can she handle this? Under the old version, if you had chosen that my agent will act only when I'm incapacitated, the doctor would say, she's not fully incapacitated, I can't talk to you. Now that we have this much more broad sort of creative middle ground option, in that scenario, the doctor can actually have a conversation with the agent and say, look, here's where we are. Maybe her short-term memory is a little off sometimes, but she is still okay in paying regular bills. Now, big picture, you may not want her making large financial decisions. So it's interesting, the interaction between all of these documents and why it's so important to have the trust and the powers of attorney, both financial and healthcare power of attorney.
Yeah, and that's what I was going to add with the trust. So just kind of thinking back to now you have this account, you open the trust, name it in the title of the trust, and that's something that the custodian wants a copy of. Who are the trustees? So they have, so to your point of it is easier to act as a trustee, it definitely does give them, like here's who's next. So if we're saying we're moving on to the next one, they know, okay, and they're just asking, okay, why? But you move on because you have that note. So that makes sense. No, I agree and concur with all of that. It's kind of funny because it's like these are things you put in place, and then with clients we're working through, okay, now this event happens, and so now you depend on these legal documents and reading them and saying, okay, now we just put these steps into place. So no, that's really good. So I guess kind of on that same vein, great, we've talked about people who have gotten these documents in place. I guess one of the, worst things you've said is that people don't get these documents in place. Just kind of talk us through, just to help people understand how important they are. If you don't have estate planning documents in place, either, while you're living, so power of attorney, or now after you passed away, what is that process just kind of broadly like? If you don't have anything.
So you hear I always am talking about and emphasizing the incapacity and not just the what happens when I die. And I'll start with the incapacity piece. It's really unpleasant if someone becomes incapacitated without those simple powers of attorney in place. At that point, your option, really the only option you have, is to go into guardianship court, which is, you can imagine, expensive, stressful, it's an emergency situation, and sometimes when you have an elderly parent, it can happen at any time. And there's no wiggle room. I mean, if you don't have, like Schwab power of attorney, for example, if you don't have the right document in place, you're stuck, and you can't do anything with the finances until a judge has granted you guardianship. Another huge downside on that piece is someone may end up being appointed as guardian that the principal would have never wanted, because it's really a judge unfamiliar with the family dynamics and the situation is going to just, all they can do is look at the circumstances and say, okay, you're the oldest child and an accountant, I guess you're a good choice. And they won't have any idea about any of the backstory. So to us, it's so important not only to avoid court and all of that headache, but also to pick who you want. So that's on the incapacity side. And same is true with the healthcare decision making. It's horrible if you don't have that document and there's an emergency situation. On the death side, similar issue in that the court has to get involved. Now you're in probate court. If you die with nothing in place, you're in probate court, which some people feel like, well, I don't care, I'm dead. yes, and it's very expensive, time consuming. It takes a long time for your family. But and again, some people are like, I don't care. Yeah. One thing they may care about, though, is that with nothing in place, Illinois law dictates who gets your assets.
Yep.
And it may not be who you want. Most people would assume, well, if I'm married, a typical situation, if I die and I'm married, I'm married and I have a bunch of kids. If I died tomorrow with no documents in place, you would assume that everything would go to my spouse. Not so. Yeah. It would be half to my spouse and half to my children. That is not the result most people would want. Yeah. And that can cause huge issues, even if your children and your spouse are, everybody's in agreement. Now there's all this complexity of tax issues, and even more so if you have young children. Like I have a couple kids that are under 18. Those kids in that scenario, we would have to go to guardianship court and open guardianship for each one of those kids because, the money has to be managed for them. So you can solve all this so simply, even though it is kind of not a fun process that you would seek out as, something fun to do. You solve so many potential problems. Yeah. So many.
Yeah, I just think the value of having all these things in place. I mean, I think back to a client, this was years ago, where a client had gotten these documents in place and they had several kids. It was 2 marriages. This was kind of second marriage for both of them. So you've got kids, both, and they were blending their families. And so they got these documents in place, and they actually had like a family meeting where they were telling the kids, not necessarily like, here's what each of you get, but it was, hey, mom and dad have gotten these documents in place.
Yep.
We just want you to know that because when you have some kids who are older from, a different parent, and now you're blending 2 families, they might be thinking, well, wait, now I have to share with everybody else.
Right.
So I just remember this couple was very thoughtful of, okay, I want my assets to go to my kids and, the other spouse to theirs. And so they were really thoughtful in this and just wanted to explain it to their kids. So they had this family meeting and actually had us come like as the financial advisors, but it was really fun. It was like this Christmas party.
That's a great idea.
So it was just, I think I've just seen it done so well.
Yep.
So I just think those are the things that you're avoiding. Now, I mean, if we're just kind of listing some of these things that can be potential issues, I mean, even kids going to college. So we think, we as parents need these documents in place, but talk a little bit about kids going to college and, just because you're married, just because you're related does not mean that you're exempt from needing documents.
No. And we've had clients learn that really, unfortunately, the hard way, and not in the sense that anything terrible happened, but for example, sending a kid away to school and wanting to get access to their account or help them with a financial issue, or sadly, a medical issue happened. Without the POAs in place, even though you are the parent, if that child is over 18. You have no really easy legal right to manage or get any information. And that can be especially tricky if the kid is, God forbid, the kid gets hurt and is in the hospital. You're kind of stuck. So really, that's another piece of it. In fact, we do a little plug. We have a special, deal that we do as kids are going back to college, like right now, where you can get those documents done really simply, really easily, and just feel comfortable that they're done.
Yeah. I think the biggest thing in all of these is don't assume anything.
Yes.
Make sure it's written down so that what
Choose
you
it.
want is in place.
Choose what you want. That's exactly it. Don't let somebody else make those decisions for you.
Yeah, exactly. No, this is great. Why don't people, like if you were to kind of guess, why don't people get estate planning documents in place?
Yeah, I think mostly procrastinating, we see a little bit of people get hung up on maybe one issue, who's gonna be the guardian, I don't know who would be the guardian of our kids. And they think that this is so big and such a big permanent decision, which, yes, you want to document it and have it right. But at the same time, it's perfectly okay if you name, very common, we see people name their parents as guardian of their little kids. Well, then the kids get older and the parents also get older, the grandparents, and they realize, we need to make a tweak here. My mom and dad couldn't handle my 12 and 14-year-old kids or whatever it is. Yeah. So I would say that's kind of a big piece of it is people feel as if, well, I have to have all the right answers before I start this. Yeah. And of course you want to be thoughtful, but it's all tweakable going forward.
Yeah. I think that's one of the great points is if there's things, so yes, if you want to go into it saying, here's who we've got, here's who we want to name, but if there's a spot that you just can't think of, I think what's great is when they're working with you guys, so as an attorney, you have, all this experience of knowing, well, this is what we've seen, so this is what we typically suggest, and it might really help them to kind of land on the person if they're trying to decide between two. It might really help them to land on that. Just hearing, I feel like so many times just hearing from the experience of the professionals doing these things really helps people to feel more comfortable, but also to be able to make those decisions when it comes time and not procrastinate. So
right.
That's
really
good.
I really appreciate those discussions. We enjoy those discussions because we can really add value in that space to talk through, because people don't know if they've never gone through the process. They don't know what it means to be an executor versus a trustee versus a guardian, and so it's great when we can really talk about it and let them make informed decisions.
Yeah. Okay. Yeah. Anything else you can think of we haven't touched on that you're kind of like, this is something, I'm just seeing right now that I just want to remind people is a big deal? I know we've talked about several things, but anything you kind of in closing you'd have?
I think the biggest takeaway to me is just think about them and get the documents done. Really get them done. And even though it's not anything that people are going to seek out as a fun experience, you need to just get it solved and you'll feel better. This is so many clients. You mentioned it early on in this discussion. So many clients come to the signing meeting and say, oh, that feels good. It's like checking the box and feeling like you've got it squared away. So I'd say that's kind of the biggest takeaway.
Okay, yeah. And the thing is, just remember, things can be updated. Yeah. Things can change as they change over time.
They should.
So, yeah, we're your cheerleaders. Get them done. Yeah, it's okay. This is not final, but it is a great first step. And, the documents you set in place may be your final documents you end up using, years down the road, which would be great. So, doesn't mean things have to change. No. But I think that's a great point. No, I think this has been really helpful. Yeah. Thank you for joining us, Heather.
I always love talking with you.
Yeah. I know. There's things that change. This is where it's so interesting. I think this is what's helpful for people to hear, whatever stage of life they're in, whether they have these documents in place or they don't. There's something here where they can say, oh, well, as my kids get older, I need to be thinking about how I'm going to talk about this or, just stuff like that. So I think this has been really valuable. So thanks for joining us.
Of course, anytime.
All right. So we've got a couple additional resources. We've got a video on creating and funding estate plans. Also, our most recent podcast, episode 24, about managing your parents' finances. And then coming up, Heather and I are actually going to be doing a webinar. So we're going to dig even further into more details that matter in your financial plan with estate planning. So if you've enjoyed this discussion, it will get even more nerdy. Oh, yeah. And we'll discuss a lot more technical things. So that's September 26th. So you can sign up on the link in the show notes. That'll be there. But yeah, if you find yourself in this position and you just want to learn more, that's going to be a great resource for you. So go ahead and sign up for that webinar. It's free, so you can just sign up and you'll be able to join us then. All right, well, thank you so much for listening into this discussion, and we will talk to you on our next episode.
Thanks for listening. To find any links or resources related to this episode, check out our show notes. Your host was Michelle Smallenberger, a certified financial planner and CEO. The guests featured are from Financial Design Studio, a team of experienced, fiduciary, fee-only advisors based in Chicago. Anna Lewis is the executive producer of the Behind the Designs podcast. And as always, for more information about Financial Design Studio and who we are, check out our website, financialdesignstudio.com. And final note, no content discussed on this podcast should be taken as financial advice. Financial Design Studio accepts no responsibility for your individual choices. We'll see you in the next episode.